Next case set for oral argument then is State of Ohio versus Anthony Cole. It's case number 29362. State of Ohio has waived its oral argument in this case as well, so we will just be hearing from the appellant's attorney, Mr. Smith, on behalf of the appellant. We've read the briefs and are prepared to proceed to our sir. You have 15 minutes, obviously.
May it please the court. Your honors, there were three assignments of error raised in this case. One was that Anthony Cole's convictions were against the manifest weight of the evidence. There were obviously, as is the case with many domestic violence reports, there were no eyewitnesses to the alleged incident. There was also inconclusive evidence of the injuries that Ms. Shufford allegedly suffered in this case. One of the key pieces of testimony had to do with what was alleged to be a bite mark on her thumb, on the thumb. There was a photograph that was entered into evidence. There was testimony about how the bite mark was difficult to see, and there was no DNA testing. There was no forensic testing.
I thought there was bruising, and if I remember, bruising and redness. Is that correct?
There was
testimony about that.
There was some testimony about some redness around her neck. The problem was that the amount of time that passed in between when this incident allegedly happened and the time she goes to the police. The incident allegedly happens around 3 a.m. Cole works first shift. He works for a plastics company, gets up and works about 6 to 7 o'clock in the morning. Shufford doesn't go to the police until about 8 hours after this alleged incident, which was about 11 to 12 o'clock that day. So there's about an 8-hour time period that elapses between, when this happens and when she goes to the police, and that's really the time frame where Ruben, the officer, talks about noticing this redness, noticing this bruising, or these alleged injuries around Shufford's neck. So there's some reason that establishes some reasonable doubt there as to what could have caused this. I think the main focus of the testimony was on some redness around her neck. There may be some reasonable doubt there as to what could have caused that, but the most conclusive evidence, if it were there, would be a bite mark, and the problem with that is there's no bleeding, obviously there's no DNA forensic testing done. At this point, it's difficult to establish exactly what could have caused the mark on the thumb at that point. It's hard to establish whether it was a bite mark or could have simply been a cut or some other kind of injury that could have been sustained at some point. So, and I would also point out there was no medical treatment done. So there are no ER reports, there are no doctor's notes, no other reports that would corroborate the source of these alleged injuries and would point to physical harm caused by another person.
Oh, wouldn't her testimony alone be sufficient evidence of physical harm if believed?
Yes, and there is case law that talks about if one witness is enough, Your Honor, but at the same time, we also have to look at what are her motivations to make this kind of testimony. So, she's subject to the same tests of credibility and, believability as any other witness. And the state kind of runs into this problem where when you have one witness testifying and your entire case is predicated on that single witness without any corroboration, that person, any motivations that that person may have to testify, less than truthfully or maybe shape things in a certain way is going to come out of the woodwork. And I think that's what happened here was ultimately there was an argument between Cole and Shufford. They had been living together. They've been living in the same household. Cole has has steady employment at that point, he's making a good wage. And there was an argument about, I guess, some alleged infidelity on her part. He gets angry, he talks about how he's going to move out, he's going to end the relationship. And so this provides Shufford with a motive to, kind of get back at Cole and say, well, if you're, say to herself, well, if he's gonna move out, then I'm gonna tell the police that he hit me. So, I mean, there's definitely a motive there for Shufford to fabricate or otherwise not testify truthfully. And I'd like to talk briefly about the sentence, if I may. The sentence here was contrary to law because the trial court did not consider the required factors. There was talk about the state actually ordered or requested a PSI in this case, and the trial court actually refused to order a PSI even at the state's request. And essentially what happens is when the trial court does not order a PSI, it essentially ties their hands and makes it to where the trial court has to sentence the defendant to prison under Rule 32.2. So at the point where the trial court doesn't order a PSI, the decision's already been made that the defendant's going to prison. It's just a matter of how long and what the length of the sentence is going to be. So at that point, they actually couldn't consider the statutory factors, the principles and purposes of felony sentencing, and as well as the seriousness and recidivism factors under 2929.12.
Wait, is your argument that if a court does not order a pre-sentence investigation, it's precluded from putting somebody on community control?
Under Criminal Rule 32.2, if the trial court sentences to probation, they're supposed to order a PSI prior to sentencing. So at that point, I think it ties the trial court's hands, and at the very least, it shows that the trial court's not willing to consider probation. And this was a case where probation should have at least been on the table for Cole. Obviously, it's a felony domestic violence. He has a prior conviction. However, he had basically led a law-abiding life for a significant amount of time before this case. He had no criminal convictions in the last 15 years. He had solid, steady employment, good job, a job that carried a vested pension at a plastics factory. So there are definitely some factors that the trial court should have taken into account here to decide whether this was a case that merited community control versus a prison sentence.
Did defense counsel argue all those points that you just made?
I believe there was some mention of it on the record, Your Honor, and the other issue we run into here is the sentencing hearing is, for lack of a better word, truncated, because the trial court at some point just says, I've heard everything I need to, and sentences him to prison. So
She didn't sentence him for a couple more weeks later, right? So it wasn't immediate.
well, it was, I believe it was at the sentencing hearing where where the trial court stated, I've heard everything I need to.
Right, in other words, verdict came in, she ordered him into custody, into jail, set up for sentencing.
Correct. Yes,
That's
yes.
the-
Right, and the sentencing was at a later date. But, the problem is at that point, there's no PSI, and frankly, there's an allocution issue because it's really not entirely clear from the record whether the allocution rights were totally respected here. I mean, obviously, this wasn't something that was raised. It was might have been more of a harmless error issue, but at the same time, it still shows that the trial court wasn't as careful as they could have been, wasn't as circumspect as they could have been in considering the factors and imposing a sentence here. And one other factor, just as far as whether the sentence was supported by the record, was just the strength of the evidence in this case. The evidence that he alleged of these injuries was inconclusive. There was testimony about the demeanor of the complaining witness, but there wasn't anything to put it into context, such as I had known this person, I had seen this person before, this is how they normally act versus how they were acting on the date in question. So I think there were several factors here that come into play to show that this is more of a case where the trial court didn't follow the statutory factors making a sentence contrary to law and also not supported by the record. And I'd be happy to take any questions.
Well, let's assume that the court finds there's a problem with the allocation. What would your argument be as to why it's not harmless error?
Your Honor, there was actually no, if there was a problem with the allocution there, I think there may have been some, if the court finds an allocution problem, I would say that, you know, this is normally the kind of case where, you know, a statement from the defendant might actually make the difference between probation and prison. And I think that actually might make a difference in this case, particularly since the trial court cited lack of remorse as a reason for imposing a prison sentence. And I think that seems to be one of the guiding considerations, one of the main factors that the trial court relied upon in fashioning a prison sentence was that that the trial court didn't feel there was a sufficient showing or any showing of remorse on the part of the defendant.
Yeah, I think that was based on a memorandum that unfortunately is not part of the record, where the court indicated that Mr. Cole was blaming the victim and still denying any incident happened. That memorandum, though, if I recall, is not part of the record. It wasn't a PSI, then, it was just a memorandum.
Yes, and I think there was some mention of that at the sentencing hearing. However, you know, had Anthony Cole been given an opportunity to speak, he might have been able to clear up some misconceptions or possibly make a statement on his own behalf that may have affected the trial court's decision.
So the statement may have been different to the court than it was to the probation officer, is what you're saying?
Possibly, and there may have been some, you know, as with anything, I mean, anytime there's information relayed through a third party, there may be some miscommunication or misunderstanding as to what the context of the statements were.
What about that mootness issue? Has he served his sentence?
He's not, there would not be a mootness issue, Your Honor, due to the collateral consequences of a felony conviction. This was a case where he had a prior misdemeanor conviction that enhanced this offense to a felony. Even if he's released while the case is pending, there's still going to be some collateral consequences such as firearm disability, such as possible disenfranchisement of voting rights that would carry over, and for which he would not be able to obtain a sealing of his record in order to alleviate those losses of rights. So to answer your question, there would still be collateral consequences that would carry over even if the sentence is served.
So my understanding was he had 2 prior domestic violences. Were they both misdemeanors?
I believe.
Because this was a felony of the 3rd degree.
Well, and I believe that if there were 2 priors, then the second offense by statute should have been charged as a felony, Your Honor. I'd have to refer back to the record to confirm that, but I believe the second would be a felony in that circumstance.
Judge Shaker, any questions?
We would ask this court reverse and remand. Thank you.
All right, thank you for your presentation today. The court will take the matter under advisement, issue a decision in due course. The opinions are also